Hello, everyone. Welcome back to Notarized by Christy, where we dive deep into the world of notarial law and help you prepare for the Louisiana Notary exam. In today's video, we're going to break down the essentials you need to know about trusts, specifically, as they apply under Louisiana law. So whether you're studying for the notary exam or just brushing up on your legal knowledge, this video is for you. Let's get started. First, let's define what a trust is. In Louisiana, a trust is a legal relationship in which one person, known as the settlor, transfers ownership of property to another person, the trustee. The trustee holds and manages this property as a fiduciary, but not for their own benefit. Instead, they do this for the benefit of a third party, known as the beneficiary. Louisiana law recognizes different types of trusts, each serving unique purposes. The two main categories are inter vivos trusts and testamentary trusts. An inter vivos trust, also known as a living trust, is created during the lifetime of the settlor. In Louisiana, an inter vivos trust must be executed in the presence of two witnesses or by an act under private signature duly acknowledged by the settlor. It's important to note that an authentic act is not required unless specified by the trust's terms. On the other hand, a testamentary trust is created upon the death of the settlor and is outlined in their will. This type of trust only comes into effect after the settlor has passed away. It is crucial for the will to meet all legal formalities, including being witnessed properly, to ensure the validity of the testamentary trust. Understanding the roles involved in a trust is key to managing one effectively. We've already mentioned the three main players: the settlor, the trustee, and the beneficiary. But what exactly do these roles entail? The settlor is the person who creates the trust. They decide the terms and conditions under which the trust will operate and who will benefit from it. The trustee holds the legal title to the trust property. They are responsible for managing the trust in accordance with its terms, always acting in the best interest of the beneficiaries. The trustee's duties include prudently investing the trust assets and distributing income or principal, as specified in the trust document. The beneficiary is the person or group who benefits from the trust. They have equitable interest in the trust property, meaning they benefit from it financially, though they don't have legal ownership. Louisiana law also recognizes more specialized trusts, like class trusts and charitable trusts. A class trust benefits a group of people, like the descendants of the settlor. One important feature of class trusts is that the beneficiaries may not be identifiable at the time the trust is created. They might be born after the trust is established. Charitable trusts are established to benefit the public or a segment of the public, like for educational, religious, or scientific purposes. Unlike private trusts, charitable trusts are not subject to the same perpetuity limitations, allowing them to operate indefinitely if necessary. There are some key legal provisions you need to be aware of when dealing with trusts in Louisiana. Spendthrift trusts are designed to prevent beneficiaries from squandering their inheritance or having it claimed by creditors. In these trusts, the beneficiary's interest cannot be transferred voluntarily or involuntarily, providing a level of protection against poor financial decisions or legal claims. When an income beneficiary's interest in a trust terminates, such as due to death, the trust terms dictate what happens next. Often, the trustee may need to reallocate the income interest or distribute the remaining trust assets according to the trust's terms. Property can be added to a trust at any time, either by the settlor or through authorized means, as long as it complies with the terms of the trust. This flexibility is crucial for managing a growing estate or accommodating changing circumstances. It's important to remember that Louisiana law imposes limits on how long property can be tied up in a trust. For private trusts, property cannot be held beyond the life of a surviving beneficiary, plus 20 years, or 50 years from the trust's creation, whichever is shorter. As a final point, I want to emphasize the importance of professional guidance when dealing with complex trusts. The Louisiana Trust Code is detailed and can be challenging to navigate. especially when trusts involve significant assets or complicated family dynamics. Always consider consulting a legal or tax professional with expertise in estate planning when setting up or managing trusts. And there you have it, a basic overview of trusts under Louisiana law. If you're studying for the Louisiana Notary exam or just wanting to understand trusts better, this foundation is crucial. Don't forget to like this video if you found it helpful, subscribe for more notarial insights, and hit the bell icon so you never miss an update. Thanks for watching, and I'll see you in the next video.